Welcome to the HR Spoonfuls podcast, brought to you by Andera HR, the home of helpdesk4hr.com and AI for HRhub.com, where you can find assistance from qualified human resources professionals and learn about all things related to the use of artificial intelligence solutions for your HR department. Now listen in as your AI-driven hosts, Alex and Ivy, discuss interesting and current human resources topics, one spoonful at a time.
Ever wonder what your rights are at work? You know, if you need a little flexibility after dealing with a medical issue.
Yeah.
Well, that's what we're diving into today. Those tricky waters of reasonable accommodation under the ADA.
The Americans with Disabilities Act, always a hot topic.
You got it. And to really see how this plays out in the real world, we're taking a close look at a court case, Ellen Yanick v. Kroger Company of Michigan.
Oh, this one's a real eye-opener about what an employee actually needs to say or do to, well, get their employer to step up and provide support.
It's all about those magic words, right? But seriously, imagine you're Mary Ellen, okay? You've been a dedicated bakery manager for Kroger for over a decade. She even has a track record of good performance reviews.
So we're not talking about someone who's slacking off here.
Right. But then life throws a curveball. A breast cancer diagnosis, medical leave, surgery, the emotional and physical toll alone.
Oh, absolutely. And I think that's what makes her case so powerful. She was a good employee, always met expectations, and then this happens. It really puts the spotlight on needing support, not questioning her ability.
Exactly. And that's where things get even more interesting, because the EEOC, that's the Equal Employment Opportunity Commission, they actually stepped in to support Mary Ellen's case, filed a legal brief, the whole 9 yards, to help her appeal to a higher court.
Now, that's a big deal.
Yeah.
It tells you they saw something important here, something that could have implications beyond just this one case.
It's like they're sending a message. So let's break it down for everyone. What exactly are we talking about when we say reasonable accommodation? I mean, it sounds straightforward, but...
Well, at its core, the ADA basically says employers have to provide reasonable accommodations to employees with disabilities, right? But what that really means is making adjustments or changes to the work environment, to the way things are usually done, all so that someone with a disability can still perform their job effectively.
Okay, that makes sense. But isn't that one of those things that could be open to a lot of different interpretations? What's reasonable to one person?
Oh, absolutely. And that's where this whole case gets really interesting. Because, see, the law doesn't expect you to be a lawyer yourself. You don't need to walk in there with a perfectly worded legal request, right? I hereby request a reasonable accommodation under the Americans with Disabilities Act and all that.
So no need to memorize the entire legal dictionary.
No, not at all. The EEOC actually emphasizes using plain English, speaking clearly, in a way that your employer can understand.
So no need to memorize legal jargon. That's a relief. But it does make me wonder, what did Mary Ellen actually say to her manager that has the EEOC so interested in her case?
Well, remember, she's just 1 week out from surgery, right? She returns to work and is immediately thrown back into the thick of it, working a grueling 53-hour week. Just picture yourself in that situation for a second, recovering from surgery, dealing with the side effects of treatment, and then, bam, back to long hours on your feet.
Okay, yeah, I can see where this is going. I'd be pretty overwhelmed, to say the least.
Exactly. And to make matters worse, only 1 week in, she's called into a meeting with her manager, Marley Schnepp, who tells her things are not to standards in the bakery department. Now, you have to keep in mind, Mary Ellen has a history of good performance, so this feedback comes across as a real gut punch.
So she's blindsided just when she's at her most vulnerable. Ouch.
Exactly. And how does Mary Ellen respond? She tries to explain that she's struggling physically to do the job and needs time to get back to normal. Now, to the EEOC, those words, spoken in that context, should have been a clear signal to the manager that Mary Ellen needed some support.
And this is where the interactive process you mentioned earlier comes into play, right?
Precisely. And the EEOC argues that by not picking up on Mary Ellen's need for accommodation and engaging in that interactive process, Kroger may have failed in his duty under the ADA. Remember, the interactive process is a two-way street. It's about the employee communicating their needs and the employer working with them to find solutions.
So it's not just about Mary Ellen needing to use the magic words. It's also about Kroger being an active participant in finding a solution that works for everyone.
Exactly. And think about it, she wasn't asking for the world. She was simply saying she needed some time to get back on her feet. The EEOC argues that a modified work schedule, maybe cutting back on those 53-hour weeks, could have been a perfectly reasonable accommodation in this situation.
It seems like common sense, especially when you consider everything she was going through. I'm curious, though, is there anything specific in the EEOC's legal brief that spells out why they think Mary Ellen's request was enough to trigger Kroger's responsibility?
Oh, absolutely. In fact, they point out that Kroger knew about Mary Ellen's condition, the surgery, and that she had just returned to work.
So they're saying basically this wasn't a surprise for Kroger.
Exactly. And they're arguing that when she said she was struggling physically and needed time to get back to normal, especially considering that 53-hour work week right after medical leave.
Yeah, that's a lot to handle.
Right. That should have been a huge red flag to Kroger. Like, okay, we need to talk about possible accommodations here.
It's like saying, hey, pay attention, something's not right.
That's what the EEOC is saying. They're arguing that Kroger had a responsibility, a duty, to really understand what Mary Ellen needed and then try to find solutions with her to work together. And by dismissing the case, they're basically saying the lower court let employers get off too easy.
So this isn't just about Mary Ellen Kroger anymore, is it?
Not at all. The EEOC is using this case to make a bigger point, a precedent about how reasonable accommodation should be interpreted in future cases.
It's setting the stage for how these situations should be handled.
Exactly. If the higher court sides with the EEOC, it could send a huge message to employers everywhere, basically saying, when an employee says they're struggling, especially after a serious medical situation, you need to listen, engage with them, and actively try to find a solution that works.
Don't just brush it off.
Exactly.
Makes you wonder how things could have been different if Mary Ellen's manager had just taken a more proactive approach, been a little more understanding.
Absolutely. And that's why this whole case is so important, so fascinating. It underscores just how important open communication is at work, especially when it comes to employees with disabilities. Empathy goes a long way.
Couldn't agree more. This deep dive really brought something to light for me, and I hope for our listeners too. It's so important to understand your rights as an employee and to remember you're not alone in these situations.
Absolutely. Knowledge is power.
100%. So to everyone listening, put yourselves in Mary Ellen's shoes for a moment.
Yeah.
What would you have done? How would you start that conversation about needing some flexibility at work after a medical situation?
It's something to think about for sure.
Yep. It really is. Until next time, everyone, stay informed, stay curious, and as always, thanks for taking this deep dive with us.
Thanks for listening to HR Spoonfuls. For more episodes like this one, drop by helpdeskforhr.com or AIforHRhub.com and subscribe to our newsletter to receive HR updates and notices when new podcast episodes are posted. We hope you enjoyed the conversation and will join us again soon.